Hello, and welcome to John's Rants. We're going to do a rant today on a couple of issues regarding some forms. I want to make sure that everybody's feeling comfortable with the new RPA and a couple of risk management issues. And I also want to tell you about a form that's coming out in June. So first of all, let me tell you what's going on with a new form in June. There's a law that's going into effect on July 1st, and basically it is a response to some fair housing concerns that have been expressed at both NAR and CAR with appraisal issues. Apparently, there's been some evidence that if you are a member of a minority group, you do not get an appraisal done as fairly and non-discriminately as if you were a person, a Caucasian person. And so the legislature in California passed a law that wherever there's a transaction where an appraisal is going to be done, the parties need to be warned that they have a right to report discriminatory appraisal issues, and the burden is going to be placed on realtors to make sure that their buyers and sellers are aware of this right. CAR is going to take the lead, and they have prepared a new form which will come out in June, a month before the law goes into effect, and it is called the Fair Appraisal Act Advisory. It will be bundled with your RPA and other documents. It will be used in every transaction where there is an appraisal, so pretty much most transactions. They will probably also tweak the RPA to check off the box under advisories. And what it does essentially is it's a little 2-paragraph form that tells the parties that they have a right to a fair and unbiased appraisal. And if they believe that they are discriminated against, a phone number and a link where to complain. So that comes out in June. Additionally, in June, they're going to start making a couple of upgrade tweaks to the RPA. Essentially, they're taking comments from membership now. If you have a problem, a real problem with the RPA, something where you've noticed an inconsistency or you've noticed some type of a problem, that you're going to be able to send your comments to CAR, and they'll probably do some minor tweaking of the form to take into account any problems that come up in the marketplace. Of course, the association will provide you with updates on anything that comes up between now and June, so that when June does roll around, you'll be able to be right on top of things. However, you are urged, if you haven't done so already, to take a class on the RPA. The association is offering numerous classes and programs to keep you current. So a couple of things have come up as we're starting to get into the use of the RPA. Obviously, I don't use it as a realtor. I'm just the lawyer for the association and for my brokerages. And so we've noticed a couple of risk management issues that I want to bring to your attention over the next few minutes. This does not replace a real class, but just some things just to keep an eye on. First of all, I don't care how well you are with the use of the form. Most of you have been using the form that no longer exists for a long time. You felt comfortable with it. You knew its ins and outs, and you're just starting to learn that with the new RPA. It's only been out about a month and a half. Obviously, all of us are learning things as transactions come up and questions and issues come up. I've taught the class a number of times, as have others, and I have a list of a number of the questions that we've been getting, and they're in the hundreds. And so slow down. Make sure you understand that this contract is significantly different than the old one. It's been changed dozens and dozens of times. It's longer. There's a grid that summarizes things. And so take your time, and until you're comfortable, slow down a little bit. Again, there have been massive changes. Not only that, but there are 60 forms referenced in the contract. Additionally, there are about 20 or 30 forms that you could use with the contract, but they're not referenced in the contract. So until you get a full flavor of how to use all that, you're opening yourself up to some mistakes, potentially some risk. And so to manage it, slow things down a little bit as you get to learn the forms, as you attend these classes, as we push out information. Hopefully you'll feel more comfortable. A couple of specific issues. There are some real-time sensitive issues in this contract. As you know, in the grid, they've added some places where if the seller doesn't provide things in a timely fashion, the buyer is not going to be held to the 17 days, but they're going to be given 5 days minimum to go over documents and to respond in whatever manner it is determined is in this buyer's best interest. So there's some really short time periods. For example, if you get a revised preliminary title report, or you get some seller documents that are late, you're only going to have 5 days to review them, decide how you want to respond, decide whether or not you need to talk to another expert, maybe a lawyer, an accountant, something like that. And you only have 5 days to do that if documents come in late. So just keep track of that. Make sure that you're prepared for it. Be proactive, and if documents aren't coming in a timely fashion, by talking to the listing agent. There are a lot of contract issues that are found in the contingencies as well. For example, the section on square footage talks about the fact that square footage is not a loan issue or an appraisal issue. It is an inspection of property issue. So if your square footage determination in the appraisal comes back and is significantly different than what you were told, that is an issue dealing with the contingency for the inspection of the property, and not for appraisal and or loan issues, although certainly it would impact those issues. Additionally, issues regarding obtaining fire and other forms of insurance are issues that do not necessarily relate to the loan or the appraisal, but relate to the inspection of the property. So be very careful about that. If you're going to do an analysis of the property and you remove contingencies because all the repairs are done the way you like them and all of those kinds of things, be mindful of the fact that you also have some contract issues with insurance, square footage, and some other things that you need to also be careful of. Be mindful of the change to the increased deposit issue. As you know, you are entitled as a seller to retain up to 3% of the purchase price as damages if the liquidated damages clause is initialed and if the buyer intends to occupy the property. The limit is 3%. There's some other factors that go into it as well. Some agents are offering a smaller liquidated damages at the beginning of the contract, but are indicating that if all the contingencies are removed or some other issues crop up during that first few days, that they'll increase the deposit to a higher number. And you need to remember that if you're increasing the deposit, you also need to be mindful that there is a DID form, a delivery of increased deposit. And that is got to be filed with the money that is being sent to escrow as part of the increased deposit. So that's in the grid and is also referenced in the body of the contract. So you need to be very, very cautious. Take a look at paragraph 5A2. It talks about the increased deposit. in a greater length. Also remember that the loan and the appraisal contingencies are separate. If you remove one, it doesn't affect the other, even though the reality is that, practically speaking, the loan and the appraisal are tied together very significantly. Their removal and how you deal with them are separate. They're not connected in terms of the contract. So if I remove my loan contingency, I am not necessarily removing my appraisal contingency. Again, remember that, that there are lots and lots of dates, and you need to really strategize with your client how contingencies are going to be removed. There could be insurance issues. There could be other issues that are not part and parcel of some bigger pictures. So you need to be careful and take a look at the contingency removal form that was updated to coincide with the new RPA to make sure you understand how you want to remove contingencies, when you want to remove contingencies, whether you're removing all contingencies or just a few. Again, remember that late delivery of certain documents, particularly the transfer disclosure statement, give rise to a continued right to cancel. The buyer will have the right to cancel for 3 to 5 days until after the seller has provided a complete transfer disclosure statement. That means that all of the sections are filled out properly by the seller, and that the AVID form and or however the seller's agent is going to fill out their portion is done correctly, and that it be delivered properly. So keep in mind that those are statutory issues. What happens if you've removed contingencies and you get documents that are late? It does not necessarily, and in most cases does not, revive the contingency. So you need to be very careful about that. So does that mean you're dead in the water? Not necessarily. You know, number one, don't give legal advice. You need to make sure your client talks to a lawyer. If they're getting documents that they're unhappy with, but are delivered after the contingencies have been removed, you may have a claim for fraud. You may have a claim for a type of fraud called inducement fraud, where if you can establish the seller never intended to comply with the contract, you might have a right under those circumstances to bring a claim. You might also have a claim under misrepresentation and or fraud. Certainly, if the seller has agreed to provide certain documents and fails to do so, you may have a claim for breach of contract. There may be a claim for the covenant of a breach of the covenant of bad faith, of good faith and fair dealing. And there's a thing that lawyers use periodically called anticipatory repudiation, where you can establish that by the conduct of the seller, they're repudiating the contract and are not going to perform in accordance with it. A couple of other minor issues, not minor issues, but issues that you might find of concern. They've redone the delivery of documents provision and delivery period, and they now provide that delivery can be done through links like Dropbox. You may not want to do that, so you need to decide up front if you're going to accept alternatives to actual delivery of documents through Dropbox and things of that nature. So again, in reiterating, there are a lot of traps in this contract. You've got increased deposit issues, loan and appraisal issues, investigation issues relating to the property, not just the physical property, but also issues relating to the transaction. You've got issues of time sensitivity, particularly if reports come in after contingencies have been removed. You've got delivery of documents. For example, paragraph 14A talks about all the documents that the seller is supposed to deliver within that first 17 days. Issues regarding the leased or lien properties, issues regarding inspection reports, TDS, lead disclosure, home fire hardening disclosures, defensible space disclosures, FERPTA documentation, condo documentation, NHD statements and pamphlets, material fact issues, preliminary title reports, and issues of that nature. So a lot going on there. You've got to strategize regarding what happens if there are late disclosures, and then be aware that some of the forms that are being used with the contract limit your rights as well. For example, the TOPA form indicates that if the seller cannot deliver the property where required without a tenant, that the only thing that the buyer can do is to cancel, get their deposit back, and any very, very limited cost related to that. One other issue, and I'll close for the day, that under the SPQ, they've answered a long question that many people ask those of us that do risk management, and that is, okay, we had buyer number one, they did a bunch of inspections and they canceled. I've got all those reports. Do I have to provide those to the next buyer that comes along? And the answer is absolutely yes. If you take a look at the revised SPQ that came out in December, it is quite clear now that you must provide those documents as well as any other required disclosure documents. So again, a lot going on. There's going to be lots of programs that the association is going to offer. I would be remiss if I didn't advise you that you do need to keep an eye on the association's calendar. There's all kinds of classes coming up, and I would take more than one RPA class. If all you've taken is a class on the changes, you might want to consider taking a more robust version of the class from CAR or through the association. Keep your eyes peeled on the calendar. So that's it for me today. This is John Giardinelli signing out on John's Rants. You guys have a good and safe week. Thank you very much.